Good morning, everyone. My name is Adam Long. I'm an attorney with the law firm of McNeese, Wallace & Nureg. I figured before we get started, we thought it might make sense for everyone, since we have a small group, to go around the room and introduce yourself. Let us know what county you're from and also what position you hold in your respective districts. So why don't we start over there on the right. I see a couple of familiar faces here. For those of you who I may look familiar to you, I've done trainings and seminars like this in the past with the conservation districts. I have worked with the conservation districts for about 10 years, either through trainings and seminars like this or one-on-one individually with districts. I am an employment attorney. All that I do is work with employers on both complying with employment laws and then defending the employers in the event of a dispute or claims filed against an employer. My background is such that I only work on the employer side. I'm only ever on your side in cases and matters. I only represent employers. And with the 10 years or so that I've spent working with the conservation districts, I've gained some familiarity with how you operate and the unique challenges that each of you face as conservation districts. The bottom line is, as conservation districts, if you have employees, which virtually all of you would do, whether they be county employees or independent district employees, you are an employer under the employment laws. And virtually all of the employment laws require employers to understand the law. There's the adage that you learn in your first year of law school: ignorance of the law is no excuse. And that applies with particularity to employers. There are many legal requirements that exist that apply to you as employers. I often say that common sense will get you through about 90+% of the law, meaning just relying on your own good judgment will have you comply with most laws. That's why you don't have to hire lawyers to live with you and tell you when you wake up in the morning, don't steal your neighbor's newspaper, don't drive 100 miles per hour, things like that. Good judgment usually takes care of most things for you. However, I can also tell you in the employment world, there are areas where common sense will get you in trouble, where doing things that would seem to be obvious and good judgment and make sense could have ramifications that at the end of the day could cause legal issues for you and your districts. And that's why we do these seminars periodically. I think the last time we've done a seminar like this was 2007. This seminar is pretty much a soup to nuts of the issues that we think are most pertinent for conservation districts that come up most often. Many of them are generally applicable to all employers. We'll talk about areas where they apply, where they have specific ramifications for conservation districts. Each of you should have gotten a copy of our written materials, the bound materials. Those materials are certainly yours to keep. I have a couple of extra copies. If any of you would like to take an extra copy back to either someone at your district or for the folks from DEP here, if you'd like to take a couple extra copies for maybe some of the districts that you work with that aren't here, feel free. We're also filming today's training. I think it's going to be available to everyone to watch in the privacy of your own chambers at some point. We also have the written materials available in PDF form. Jan has a copy of those and can get those to you. So the purpose of today is to make this of most value to you that we can. And you are the third of 3 seminars that we've done. Last week I was in Pottsville for the folks on the eastern half of the state. On Tuesday we were in State College, and today is the last stop here in Portersville. So to make this as useful for you as possible, I strongly recommend, if you have questions, ask them. I don't think you want to hear me talk at you for 4.5 straight hours today, including our half-hour break for lunch. Full disclosure, I realized yesterday that I believe I'm in the process of losing my voice, so I'll do the best I can to plow through here for 4.5 hours, but certainly if you're sitting there, you have any questions, feel free to raise your hand. I'll address them. If you have any questions you don't feel comfortable asking in front of the whole group, I'll stick around afterwards today. I think we're done at 3. I'll stick around as long as you'd like me to answer any questions you would have at that point. And then finally, I think Jan distributed note cards to everyone. After today's seminar, we're going to be scheduling a webinar. For the purpose of the webinar will be to answer any questions that either I could not answer in the moment here, that happens sometimes, or questions that are asked that perhaps today that are asked that I can answer, but we think that all the districts should hear that. So we'll do the webinar as basically a Q&A. So if you have any questions that feel free to ask them or ask me afterwards, or if you'd rather just write them down and submit them to Jan or me, that would be great too. But certainly feel free to take advantage of that. We have had lots of good dialogue in the other 2 sessions we've done so far. I think it's gone very well. Lots of questions. It makes it fun. It makes it more interactive. And the bottom line is, if you're experiencing a situation or you have a question, something's unclear to you, there's a good chance that someone else in this room either has a similar situation or a similar unclarity. So feel free to fire away. With these written materials, there's about 100 pages of written materials there for you. The presentation today will track the written materials. These are the sections in your written materials. I'll refer often to specific page numbers in the written materials. I can't promise you that I will necessarily get through everything. Part of the purpose of preparing materials like this is designed to be a resource for you going forward. We only do these seminars once every couple of years, and these materials are hopefully something you can take back to your districts, and if something jogs your memory, hey, didn't the lawyer talk about something? Hopefully you can use this as a resource going forward. So while this resource is a companion to the presentation today, it's not meant to, it's meant to have a useful life long after this presentation. So feel free to take it along with you and keep it. The table of contents page, at the bottom of that page there's a web address for www.palaboranemploymentblog.com. That is my law firm's labor and employment blog focused for Pennsylvania employers. I would invite you to visit that site. You can sign up to get free email updates whenever we post something to the blog. We update it regularly when something new or of interest comes along. It's completely free. Sign up. Just, one of the things about the law, especially the employment laws, they're constantly changing. They're constantly updates. There's things that we're going to be talking about today that are different than what we talked about 7 years ago in 2007. And by signing up for the blog, it's a handy resource for you to get updates when something new or novel or interesting or just, hey, we're seeing this a lot, beware, comes along. And that web address is there for you on the table of contents page. We start with hiring, as that, we're here to talk about employment management. I'm an employment lawyer. Where does employment begin? With hiring. And that's where we start today. Hiring is one of those areas where common sense can get you into trouble. And what I mean by that is the goal of the hiring process is to obtain as much information about your candidates for employment that you can to help you make the most informed decision possible. Because if you've been doing this long enough in management, whether it be at a district or just managing employees in general, I'm sure you've had a situation where you've hired somebody and either a couple of weeks or a couple months later you're sitting there thinking, what a mistake I've made. And if I just would have known X, Y, and Z, if I had a time machine and could go back in time, if I just would have known, I would have made a different decision. So one of the easiest ways to approach that is, let's have the most comprehensive hiring process that we can to get as much information as we can that are relevant for the hiring process. That's what we want to do. Now, I say here balancing act, because if it's just about getting as much information as possible, that's not a balancing act. The balancing act is we need to balance our desire to get as much relevant information as possible with avoiding unlawful inquiries. There are many, many areas that you as employers are either expressly prohibited from getting into as part of the hiring process with your candidates, or it is a very good practice to avoid. And you may think, well, yeah, that makes sense. There's certain things that we can't ask, and why can't I just rely on my common sense and good judgment to get me through that? Well, you'd be surprised how many parts of the hiring process, things that are don'ts, don't ask about this, don't do that, are things that actually would seem at first blush, well, yeah, I would want to ask about that. What's one example of that? Say you have a candidate come in for an interview, and you happen to know that candidate from the community, maybe you have mutual friends, or you go to the same church or something like that, and you happen to know that that candidate has 3 children under the age of 10, including a toddler at home. It might occur to you to ask that candidate, part of this job is working regular hours. We expect regular attendance as part of this job. I know you have small children. Do you have plans for childcare? Or I know you just told me you just had a baby. What are your child care plans? Do you have plans to take care of child care arrangements? At first blush, that would seem to be a very relevant question. Come on in. It's all right. We would want to know about that because we don't want to hire someone who is going to call off work 3 days a week because the babysitter fell through or the child is sick or something like that. So why can't we ask about child care arrangements? Well, I would ask you a question. If that candidate sitting across the table from you, if it was me, would you ask me that question or would you ask my wife that question? I'm not saying I'm not going to poll people, but odds are most people would ask my wife that question and not me. And the reality is that's a question that has some underlying gender bias to it, and we want to stay away from that. Now, what can we ask? This job requires regular attendance. We expect you to be here pretty much every day. It's a critical position for our district. We need you to be here and have regular satisfactory attendance. Can you do that? Yes or no? You could ask that question because you would ask that of anyone. Because frankly, there's lots of different reasons why people miss work other than just child care arrangements. So child care is one of those areas where you may think just good judgment. I want to ask about that because I want to make sure I'm not hiring somebody who's going to be calling off 3 days a week, but asking a question dedicated to child care is not a good idea because it's likely one that you would not ask of a man and maybe more likely to ask of a mother. There's lots of areas like that that we'll talk about. So that's the balancing act. Getting the relevant information that we want while avoiding the landmines, avoiding the things that we just want to stay away from. And then in addition to that, there are certain areas under the law that we can get into in the hiring process, but we can only get into at a certain point. And we'll talk about medical inquiries and disability-related inquiries. When can you make inquiries like that? It's not right out of the gate. You have to, there's a specific timeline when you can do that. So that, we'll talk about how we walk that tightrope, how we handle this balancing act of getting the relevant information we want. And it really is a balancing act, because you may be thinking, well, the lawyer's saying there's all these different areas that we can ask about and shouldn't ask about, so I'm going to try to keep my questions brief and not ask about anything. We don't want to do that because no one wants to hire a bad candidate. If you can avoid that, it is such a cost in terms of time, energy, effort. You want to do the best you can to make the most informed decision possible. And you can do that while keeping in mind certain principles, certain do's and don'ts. So starting with advertisements on page 2 of the written materials. Must you use written job advertisements to fill positions? The answer is no. There's no law that requires, sometimes I get this question even from districts. We have this position, we know someone in the community who would be great to fill this position. Do we have to go post a job advertisement? Do we have to go through this cost, this time, and do all of this? Is it legally required? And the answer is no. But many times, folks do that, post job advertisements, because it's helpful to get a diverse and qualified candidate pool. You typically don't want to interview one person and hire, just there's one person, we'll consider one person for this job. There may be more candidates out there. So usually it's a good practice to consider advertisements or some way to publicize, whether it be on the internet, whether it be in local newspapers, publicize that you have this job open. Legally, it can be advantageous because hiring via word of mouth is sort of a double-edged sword. It can be very helpful in certain situations because the person that you find out about maybe already knows what employment with the district is like because he or she has a friend or family member that is affiliated with the district. So you're getting a candidate who right out of the gate is pretty knowledgeable about what the job entails. The bad side to hiring by word of mouth is we often shoot for and want to have a diverse workforce if we can. We like our workforce, the demographics of our workforce to match our community. And if we hire by word of mouth, many times we'll simply perpetuate the demographics of our current workforce. If you happen to have a federal contract, a contract with the federal government, you may have affirmative action obligations. You would know that as part of the federal contract or the grant. And there, with those obligations, the largest part of the affirmative action obligation is trying to recruit a diverse candidate pool. Affirmative action doesn't mean quotas. It doesn't mean you need to hire, well, let's see, if in your workforce 15% of the individuals who live in your community are blank, then 15% of your employees need to be blank. That's not what affirmative action means. the focus of affirmative action is how are you hiring? What are the processes that you're using? And one of the best ways to meet your affirmative action obligations is to show that, look, here's the way we go about hiring. Here's where we advertise. We reach out to folks. Perhaps, their veterans are covered by the affirmative action laws. So we reach out to local veterans groups to publicize job openings, things like that. That's the kind of thing you want to do, especially if you are covered by the affirmative action requirements. But with respect to an advertisement, even if you're not, it's always helpful in a written advertisement to include reference to equal employment opportunity. You'll see EEO employer in a job advertisement. It's just one of those things that's useful to have. The last session we did, someone asked, do we really have to put in there equal employment opportunity employer in an advertisement since we have to pay by the space? And the answer is it is a good practice, and if you're an affirmative action employer, it's actually required. But the way to do it is to abbreviate it. Like you'll see we have on page 2 a little, in quotes, phrase abbreviation in there, especially for those employers, those districts who may be covered by the affirmative action requirements. Put that in there. Many individuals don't know what that means, but the folks that it matters to will know what that means. Job applications, the application form itself. I would recommend that every district use a uniform job application form. Whenever you have someone applying for work at your district, have a form that you use and have each individual fill that form out. Just for background, how many folks here, how many of your districts have county employees? Meaning, I see one back there. So I'm assuming the rest of you, your districts are independent districts, meaning you hire and manage your own employees. That's good. There's pros and cons to having county employees, as I'm sure folks who have that experience can share, and there's pros and cons to being independent. One of the pros of being independent is you have a lot more control over your employment and hiring process. So, especially for those of you that are affiliated with independent districts, it's good to have a job application form. For those of you that have county employees, I'm sure that's handled through the county. Because one of the nice things about an application is it will get you a uniform set of information for each candidate. It's as consistent as possible because every candidate has to fill out the same information. And with a lot of the landmines we talk about, the things you want to avoid, the do's and don'ts, an application is great for that because it can make sure you walk the straight and narrow and don't get into, like in a job interview, there's more flexibility in a job interview. You're going to ask questions, and with that flexibility, you can potentially get more information, but also get in trouble a lot easier. So there's a number of areas of information that you may want that's best to get on an application form. And we talk on pages 2 and 3 about, in the bullets there, the information that you may want to include on any application form. One, a reminder that the job is for at-will employment. And we'll discuss later when we talk about discipline and discharge what at-will means and what it doesn't mean. But that's something that's important to have there, a reference to at-will employment status. If you do any background checks as part of your hiring process, if you pull criminal histories or maybe even do credit checks of certain candidates, it's good to let folks know up front on the application form that that's something we may do. We don't want to surprise them with that later because frankly, that's a waste of their time and yours. If you have a candidate who knows that he or she has a criminal background that would not be conducive to being hired for the position for which he or she's applying, you don't want to spring that on someone well down the road because you'd be wasting your time and theirs. If you do same thing with drug and alcohol testing, if you have to do pre-employment drug and alcohol testing, let folks know up front on the application form that you do that. And then finally, it's always helpful to have a guarantee, to have the candidate certify that everything I say on this application is complete and accurate to the best of my knowledge, and make clear that if it's not, false or misleading information on an application form is both grounds for the denial of your candidacy, and if we hire you and later find out you falsified the form, grounds for termination of employment. Yes?
On these background checks, you're saying if we have a check-off box for notification on the application, I was always told to have a separate form that they actually had to sign that they acknowledge we're going to do a background check, we're going to do this check. And just not a general when they sign the application.
Yeah, that's a good question, and it's actually good to have both. And we'll talk a little bit later about criminal history searches and things like that. There are requirements. If you use a third party to do those searches, like a background check company, there are requirements under a federal law called the Fair Credit Reporting Act that actually require a separate disclosure and authorization form. So you're exactly right. Certainly in certain situations you will need to use a separate form, but it's also good up front to just have the individual acknowledge that we're going to do these checks, because usually most employers only do the criminal background checks later in the process. You're not going to run those checks on every single person who submits an application. You're going to winnow down your pool typically and either run that check on either your final candidate, or maybe you narrow it down to 2 or 3 top candidates. So oftentimes they're signing that separate form perhaps later, and those are the situations it's best up front to let them know that you may do those types of checks, because people that have certain types of criminal histories, they're looking for that, and if they see that, many of them will say, you know what, all right, I'm not even going to apply here. So it saves everybody time in the process. Now, that is things that should be on an application form. Now, what shouldn't be on an application form? And that's listed on the bullets on page 3. Some of these are kind of silly, but I always laugh. Just background on what I do in my job. I always categorize my job as really having 2 different halves. One half is more compliance, working with employers to help them comply with the employment laws, provide counseling. A lot of my day spent taking calls from clients. Hey, we had this situation, this is what this employee did, how do you think we should handle this? Walking through situations like that. Or doing trainings like this, giving employers guidance and information, sort of when there isn't an issue, the pre-dispute compliance, that's one half of what I do. The other half is when disputes arise, represent employers and defend them in those suits, whether it be before government agencies or in federal or state court. And as part of that, to start, it's amazing how many times I'm defending a matter and I'm sitting there and I'm looking at something and thinking, oh, if we just had a time machine and could go back in time and undo something that was done, an innocuous statement or just an oversight 8 months or 12 months earlier. So a lot of what I see later in defending claims affects my presentations here, where I can talk about where things go wrong and where a little bit of preventative maintenance, an ounce of prevention is worth a pound of cure. That is absolutely true in this context. But one of the areas that I always laugh about is occasionally, as I'm defending a claim, we'll be defending a claim filed by a very long-term employee. So in the personnel file will be a job application form filled out in perhaps the early 1980s. And to see what job application forms look like in the 1980s, it is like fingernails on a blackboard, or sometimes even the 70s or 60s, believe it or not. The questions that are asked on application forms are so out of bounds and so dated that, back then it was, how many children do you have? And even let's said here, fill in Mrs., Ms., or Miss, things like that. We don't want to ask questions like that. Marital status. It's irrelevant to the job whether someone's married or not, so we don't want to ask that. Child care arrangements we talked about. Height and weight. I have seen job applications forms that ask for height and weight. And unless you're applying to play in the NFL, you probably don't need to be disclosing your height and weight to an employer. Color of eyes and hair. Crazy. I've seen it. Why is it a problem? The best defense to a discrimination claim, and that's really a lot of what we're talking about with the hiring process. We're trying to avoid a discrimination claim. You did not hire me because I am blank. Because of my race, my religion, my national origin, my gender. All of those things are protected on the basis of a discrimination claim. What is the best defense to any discrimination claim? I had no idea you were blank, so how could I possibly have discriminated against you because of it? That's why so many of these areas that we don't want to get into in the hiring process, like medical and disability issues, we don't want to get into that because we don't want to know about it. Because at the end of the day, then someone can't say, you did not hire me because of my disability. Color of eyes and hair. Believe it or not, you're going to get applications where you're going to look at that and say, this person's not qualified, we got better candidates, where you never even meet the person or talk to the person. Well, if you know their eyes and hair color, there's an argument that we may then know their race or something along those lines. So it's silly, but I've actually seen it, believe it or not, and The U.S. Equal Employment Opportunity Commission, that's the federal agency that enforces discrimination laws, specifically has guidance that says you can't ask about this stuff. So those ones are pretty silly and obvious, but how about date of birth? Well, we need that to run our background check. Well, we need certain information from you. We don't want it on the application form because then we know the person's age. And age is a protected trait under the law. So what do you do if you need the age to run the criminal background check? Two things. You either solicit that information after you've narrowed it down. You're not asking that information of all applicants for positions. Because if you never interview Johnny or never talk to Johnny, you just look at Johnny's application and say you're not qualified, he's not going to be able to file an age discrimination claim against you. But if you ask for date of birth, right there, Johnny says, well, you didn't interview me because you saw I was 66 years old. We don't want to know date of birth, so we don't ask it. And if we do need it for a part of the hiring process, we either ask it later and/or ask it in a way that the decision makers never see it. And what do I mean by that? Maybe you have a form that your background check company needs you to have these individuals fill out: name, last known address, social security number, date of birth, so they can check someone's criminal history and background. Have the person fill that out and give it to someone in your organization who will have no role in the hiring process. That person then can coordinate everything and then ultimately get back to you on the criminal history without the decision makers ever seeing the age. Sort of put up that wall and that protection. It's a best practice. I've seen claims filed by people who have to write down their date of birth on anything in the hiring process and don't get the job, and later come back and say, you didn't hire me because of my age. If we need the date of birth, solicit it and handle it in a way that that information never gets in the hands of the people who made the ultimate decision. They couldn't have discriminated against Johnny because they had no idea of Johnny's age. We handled this in a way that the decision maker never saw Johnny's form. How about dates of school attendance? Why can't we ask about that? We can ask about educational background on a form, and maybe we want to know the dates of the school attendance so we can verify education easier. Well, if I tell you that I graduated from high school in 1986, unless I was an extraordinarily poor student, you're probably going to be able to do the math and figure out 86 minus 18, that means he was born in 68, that means he is, you can figure out an age. It's a backdoor way to find out age. A seemingly innocuous question, you take it off the application form. And then finally, anything related to health history. There's one question you can ask about an employee's medical history or health history before you make an offer of employment. That question is, can you perform the essential functions of this job with or without a reasonable accommodation? Yes or no? If you're going to ask that question, ask it on the application because it's a very specific question. We talk about that a little later. But anything other than that, workers' comp history, anything like that, you can't get into it. What about U.S. citizenship? You may be thinking, well, we have to hire people that are lawfully authorized to work in the United States, so why can't I ask about that? You don't have to be a U.S. citizen to be lawfully authorized to work in the United States. So what you want to ask on an application form is, are you legally authorized to work in the United States, yes or no? Now, if you hire that person, then you'll have them fill out the Form I-9, and they'll have to give you the documents and that to prove. And that's all well and good, but we don't want to ask about citizenship because national origin is a basis for a discrimination claim under federal and state law. Meaning if I am born in Canada and you don't hire me, I can say you didn't hire me because my national origin is Canada. Sounds crazy, but we want to stay away from citizenship and instead focus on the legal right to work in the United States. English language skills, you have to be careful about that. Certainly there are jobs that require the ability to communicate in English. My job, for example, if I spoke no English, I would not be qualified for my job. Where employers get in trouble is sometimes they go overboard and say, we need somebody who speaks English fluently, or we need someone who speaks without an accent. And that's where you start to get into trouble, potential discrimination against individuals for whom English is not their native language. This was a really big issue for a long time with fast food employees. A lot of fast food employers had very high, you have to be able to speak English to be able to work the register and things like that, and it would preclude a lot of individuals of Hispanic descent and things like that. And what the EEOC said over time is, yeah, you need to have some ability to communicate in English, but you can't set the bar that high because frankly the job doesn't require it. You don't need an English lit major to run a cash register at McDonald's. You just need someone who has the basic skills to communicate with your customers. So just keep that in mind. If you have a candidate who maybe speaks with a heavy accent or something like that, ask yourself, can this person still do the job? And if the answer is yes, great. If they can't, then maybe we have an ability to exclude. Weekend or holiday work probably doesn't come up much for districts, but that's another thing we want to be careful. If it's truly a big part of that job, you can ask about it. But if it's not, realize, why is this a problem? Religion. You get into then, if you say this job requires Sunday work, if somebody is a regular attendee of a church and says, I can't work, we have an obligation to accommodate individuals' religious needs if it doesn't present an undue hardship or undue burden on us. So we want to be careful about how we address that. Educational requirements. A lot of your jobs, particularly with districts, have educational requirements. We might want to hire only someone for a certain tech or engineer position that has a Bachelor of Science degree in one of the following fields. That's okay. Just make sure that you feel comfortable that the educational requirements truly are related to the position. Where does this come from? Well, a long time ago, one of the areas in the Jim Crow South where folks tried to find a workaround around the discrimination laws was to put educational requirements on jobs that were not truly related to the job. For example, factory job, pushing a broom all day, you need to have a high school diploma. One of the reasons that was done is folks in that community, people of color, had a far higher percentage of those individuals did not have high school diplomas. So it was a way to exclude individuals without coming right out and saying, we're not hiring you because you're African American. So many years ago, the Supreme Court said you can't do that. That's discrimination. It's what's called disparate impact, a discriminatory impact. It's a facially neutral condition. We're not saying we're not hiring African American individuals. It says we're not hiring individuals who lack high school diplomas, which some white people lack high school diplomas. But it's a policy that's not really related to the job and has a discriminatory impact on certain groups. That's what we need to avoid. That's a type of discrimination. So just make sure your educational requirements match really what the job entails. Yes?
Can you ask for college transcripts?
Sure. Question was, can you ask for college transcripts? And if it's relevant to the job, absolutely. Often what I would suggest there is you do that later in the hiring process, as college transcripts can. I wouldn't make anyone who fills out an application form provide their college transcripts, because again, we might get a good idea of what their age is, and if we're never even gonna, if we look right off the bat and say, not qualified, I'm not gonna interview this person, we don't necessarily want that. But as you get farther down the hiring process, where maybe you're interviewing candidates, or you're close to making a decision, then it's entirely appropriate to say, can you provide us with a copy of your college transcripts to verify the education and to make sure that this person took the classes you need and maybe didn't flunk all the classes that are important to the job in question.
So you wouldn't advise actually putting it in the job ad in the newspaper that college transcripts be supplied?
You can. It really comes down to a risk-reward kind of thing. Are the benefits of getting the college transcripts right up front rather than a little later in the process, do that outweigh the possibility of the mild risk of getting to know when someone graduated from college? I would prefer that we get that information later or be held separately, but if you say, you know what, with our hiring process, we need to move quickly, so we need all that stuff up front, it's not unlawful. It's just a question of whether you can delay that a little bit. Maybe you just say, maybe the advertisement doesn't say that. Maybe it says the educational requirements, but when you have someone submit an application, say, look, we may later require you to provide your college transcripts, and let them know up front. There's lots of different ways you can get at it. Ideally, you get that later in the process, or if you're going to get it earlier, have somebody have that and maintain that without it being a decision maker, so that you only access it later in the process. If someone were to come forward and say, well, my college transcript confirmed my age, and then you figured out my age and did interview me, well, no, we get the college transcripts, but the office administrator keeps them separate, and the district manager only looks at the transcripts later in the process. Just something to think about. If you look at them truly with the application form, yeah, I would require them. I mean, get them up front if that's what your process is. If that provides value to you, do it. Military service, being a veteran is a protected trait under the discrimination laws, believe it or not, and I'm always puzzled by that, because I certainly don't live in a community, and I never have, where being a veteran would be looked upon negatively, but there are laws, at a different time and a different era in American history where that might have been the case. So there are laws that protect against discrimination on the basis of being a veteran. So it's certainly appropriate to ask about military service if it's related to the job, but just be aware out there that these laws are out there, and be careful at how we ask questions. And also, a dishonorable discharge should not be an absolute bar to employment. We can't say if you've been dishonorably discharged, we won't consider you. We can try to get more information about that, and it may be a factor, but it can't be an absolute bar. Criminal convictions, on page 5 in the written materials and 6, we talk about the Pennsylvania law. Under Pennsylvania law, employers may consider only a candidate's felony or misdemeanor conviction to the extent that it's related to the job in the hiring process. So what that means is you cannot consider arrests that do not result in convictions when you're hiring an employee. You cannot consider convictions for summary offenses. And frankly, even felony and misdemeanor convictions, you can't use them as an absolute bar to employment. Meaning, I still have clients that say to me, I will not hire an ex-con. If you have a conviction, I won't even consider you. The law would say that is unlawful, both under the Pennsylvania law, because you have to establish that it's relevant to the job in question, and under the federal laws, the federal discrimination laws, the U.S. Equal Employment Opportunity Commission, this is one of their big priority enforcement items right now, the use of criminal histories. And talk about employers being pulled dramatically in two different directions. We're in a day and age where more and more employers do criminal background checks because, frankly, you don't want to hire someone who has some heinous criminal history and have that person do something awful in the context of his or her job, and to come out later that if we just pulled the criminal history, we would have found out that that person was just paroled for having multiple sexual assault convictions and things like that. You can easily come up with a horrible worst-case scenario. So, and especially, believe it or not, after the Jerry Sandusky mess, many employers really began then saying, we want to do criminal histories on people. We want to make sure we don't have the next Jerry Sandusky. Now, the irony is, pulling Jerry Sandusky's criminal history would have came up with this much because he had no criminal history. The fact that he had been investigated before would not show up in criminal history. So his criminal history would have been completely clean. But still, you have more and more employers focused on, we want to get that information. We don't want to hire somebody who's, maybe convicted of embezzlement from a prior employer to be in charge of the district's finances. You absolutely would want to know that and factor that into your hiring process. So more and more employers are pulling that information. It's more and more accessible in the technology age we're in. However, the EEOC sees that and says, A, excluding folks with blanket policies on we don't hire anyone with criminal convictions, or we're rarely ever going to hire anyone with a criminal conviction, that may have a disparate impact on certain minority groups. That may be discriminatory because certain minority groups tend to have higher rates of incarceration and convictions. So they have a problem with it from that perspective. And secondly, if you're hiring, we have this notion that the whole point of going to jail is rehabilitation. The whole point of being convicted of a crime is we want to rehabilitate people. If we basically take the position as employers, yeah, that's great, we want to rehabilitate people, but I don't want to be the test case. Let that person go work somewhere else for 20 years, then I'll hire them. I don't want to bring in a recent, ex-con and run that risk. The reality is, if ex-cons can't get jobs, they're much more likely to reoffend and start the process over again. So while it's sort of the not in my backyard syndrome where, yes, as a society, we want ex-cons to get jobs and become productive citizens, but we don't want to hire them. So you get pulled in two different directions here. You don't want to hire that person with a bad criminal history, but not hiring people on the basis of their criminal history is getting some pretty intense scrutiny right now by the EEOC. So what the EEOC says basically is, what shouldn't you do? Don't have a blanket policy. Look at criminal histories on a case-by-case basis. Look at the relevant factors. How recent was the conviction? What was the conviction for? Is it related to the job? What was the person's age when he or she committed the crime? Were they 18 or was it 2 years ago? Look at everything on a case-by-case basis, and you can use criminal histories to the extent that it's related to the job, but you've got to do that in-depth, case-by-case analysis and not just say, oops, ex-felon, not hiring. That's what you want to avoid. Have a process, and if you're not going to hire someone on the basis of criminal history, we're obligated to let that person know in writing that he or she's criminal history was considered in whole or in part the reason for the decision not to hire. We'll talk a little bit more about criminal histories in a few minutes. The interview process on page 6. Any issue or question you can't ask on an application, you can't get into it in the interview either. It's the whole pre-employment process. Application, interview, you name it, just avoid it. So, what do we recommend for interviews? Have a relatively consistent and formal process. I like to see employers who come up with an outline. These are the areas that I want to cover with every person that I interview. It doesn't have to be, spell checked and on letterhead and all that, but have a list that, if I'm interviewing 3 people for this technician position, I'm going to ask each one about these areas. It doesn't have to be a script, because as we know in interviews, they often go in different directions depending on the person's background, the person's history. But if you start with an outline, you're at least ensuring yourself that we're going to cover these areas with each candidate. Relative consistency. We're not treating candidates differently. And then an outline is also a great place to make notes. Because the bottom line is, if you interview a lot of candidates, I'm on the hiring committee at my law firm. I interview lots of law students for our summer intern position. And after a while, they all look and sound alike unless they do something extraordinarily stupid during the interview and make themselves memorable, which does happen on occasion. But it's good for me to take notes so that I can help remember these candidates later. And if you have that outline, it's a good place to write the notes in. If you're asking about educational experience or experience maybe in conservation issues, things like that, you can take notes right there. Now, and I say this for my own, to remind myself of this on occasion, if you do a lot of interviews, realize that those notes that you may take later may be seen by people other than you. If there is ultimately a legal dispute over a hiring decision, you did not hire me because of my religion, those notes are fair game. We may have to produce those. So be relatively professional on them. Because sometimes if I'm sitting through a particularly boring interview, I might write some things that in retrospect I shouldn't have written. So realize you're writing these not just for your own benefit, but for potentially to be seen by others. And that's a good point to just touch on. The employment laws in general. Yes, go ahead.
Is there a time limit on how long you have to keep applications for employment and
That's a good question.
to notice or anything that
The question was, is there a time limit on how long to keep your applications for employment and or the notes that you take? First off, how long you keep an application for an unsuccessful candidate? That's really left up to, there's 2 different ways you would keep that. One is as an active application, meaning if I'm filling this position relatively regularly and I get a bunch of great candidates and I hire one, but I got a couple other really good candidates, I don't necessarily want to throw that application away, because if we're hiring for the same position 3 months later, I might want to call that person and not go through this whole process all over again. So what I would say there is there's no law that says how long you must consider an application active. It's really up to you and your own experiences, but be relatively uniform. If you hire for an ag tech position and you're hiring relatively regularly, I would say I'm going to have my own internal procedure where I'm going to keep all ag tech applications active for 60 days or 90 days or 6 months, whatever's useful for your experience. That's one way to keep the application. But if you're filling a specific position and you get 30 applications, interview 5 people and hire one, you should keep what's called a hiring file. That is all the applications you got for that job, your interview notes, all that kind of stuff. Now the application for the person you ultimately hire will likely go on that person's personnel file. So it won't be there, but it will be in the hiring file. And back on page 72 of the written materials, we have a section on record keeping and postings. I'll relieve you to know that I'm not going to be going through this list page by page and dot by dot to talk about how long you should keep, what should be in a payroll file and things like that. This is more for your background and use when you get back to your districts at the end of the day as a resource. I'm trying to see if we talk about hiring files in here. Recruitment records, yeah, page 82. under number 5, the entire recruitment file, including advertisements, postings, resumes, applications, anything related to the filling of that job, I would keep that file for 2 years. In case someone were ultimately to bring a discrimination claim or some other claim, just keep a file, the April 2004 ag tech, position, keep that file, keep it separate, off to the side, and then after 2 years dispose of it. If you want to keep those applications active for a longer period of time, you can do that, or a shorter period of time, but it's still good to keep for posterity that file for, I'd say, 2 years is a good benchmark, and then after 2 years, get rid of it and destroy it. We're talking about professionalism in the interview, professionalism when you're taking notes, professionalism in general. The bottom line, and we'll talk later about discharge claims, and while in virtually every employment-related claim that someone can file, any lawsuit, the employee bears the burden of proving that we violated the law. But in reality, we are the ones on trial. We are the ones that basically have to demonstrate to the government agency that's investigating us, or the court, the judge, the jury, look, we did not break the law. Because at the end of the day, what's going to happen is that person's just going to throw allegations against the wall. They're going to allege a whole bunch of stuff, and while they technically have to prove discrimination, we're the ones who, in reality, have to prove that we didn't discriminate. And what's going to be on trial is our process. How we conducted ourselves, how we handled ourselves, how we went about doing these things. And I can't stress enough the importance of being professional, doing the right things throughout the process, because the agencies that investigate these claims, all these folks do for a living is investigate discrimination claims. All they do is come in and really lift up the covers and look at how do these employers really handle themselves? How do they hire people? How do they manage their employees? And when they get a sense that they have an employer that's unsophisticated, that doesn't understand the law, or frankly doesn't care about this stuff, you've got 2 strikes against you right out of the gate. Conversely, when they come in and they see, look, we've got an employer that handles things professionally, they realize that this stuff is important. Whether you believe it's important or not, it's important to those investigators. It's probably not unlike when you interact with folks out in the community, what you do as districts is important to you. It might not be as important maybe to that guy who lives down that dirt road or something like that. They may think you're a pain in the behind and why are you bothering me, but it's important to you because you know the laws and you know what you do. It's the same thing for investigators in the employment world. You may say, oh, this gobbledygook this lawyer's saying, why does this matter? This is all garbage. Whether you believe that or not, I don't care. I don't give personal opinions on any of this stuff as I'm going through it, because my personal opinion is irrelevant. The people who ultimately are going to review our actions, it matters to them. They care. So to the extent that you can show that it matters to us, whether you believe that or not, that goes so far in these investigations. I can't stress that enough. And one of the areas is in the interview process. We'll talk throughout. When you're managing employees, when you're disciplining employees, it matters. Where you end up often matters less than how you got there. And going through and doing it, and I'm not saying reinventing the wheel and having to hire 6 HR people to do all this stuff. There's little things that we can do here or there that help us. For example, in the hiring process, having a consistent outline of questions that we ask for each candidate, or topics that we cover with each candidate. Being able to have that outline in that recruitment file. If your hiring process is ever on trial, right there, we can show, look, we take this seriously. We don't go in here and wing it and ask questions and go all over the place and ask stuff we're not supposed to get into. We do this right. And this is just one area where that's something that's useful. Now, I had a question asked on Tuesday that I don't think anyone here indicated that they're a director at any district. So I'll ask the question, and I do not by any means mean to offend anyone's board or any director at any board, but the question came up and I thought it might be useful. What if we have directors who ask to sit in on interviews? And what if those directors perhaps aren't as in tune to this stuff as we are, meaning I'm terrified of what that director may say or ask during the interview. What should I do? I'm not saying I know of any director anywhere in the Commonwealth who would ever do such a thing, but let's just say hypothetically that comes up. What should you do? Well, keep in mind that you as a manager or you as an official with the district and directors, you are the district for these purposes, meaning whatever you say is attributable to the district. So if you're in a situation where, or maybe you've been before in situations where you've had someone, whether it be a supervisor or director who just can't stay on script and gets into rough areas and things that I'm sitting there cringing, one, I would say maybe proactively you want to address that with your board chairperson of, maybe going forward we could change this up if you think it's a real problem. If that's not possible, talk to that director, maybe take back a copy of this nice little packet of information and say, here, this is something the lawyer gave us. But what if you're in the moment where suddenly that director starts saying, looks like, you have a bit of a limp there. You have any medical conditions or anything like that we should know about? Something that you just know, red flag, don't talk about. Gently try to move on from that, or not so gently, whatever it takes to cut that off. Because the bottom line is, even if you know the right things to do and say, and you do them, but someone else sitting in that interview doesn't, it's basically under the law, the district was saying all of those things. So we need to try to cut it off if we can. So again, not saying that would ever happen in the real world, but I just throw that out there just in case you were thinking it. Pre-employment medical inquiries under the Americans with Disabilities Act. The ADA, just as a background here, in case you see elsewhere in the materials, the Americans with Disabilities Act is a federal law. It's one of the discrimination laws. This is the discrimination law that prohibits discrimination on the basis of a disability. It requires employers to make reasonable accommodations to qualified individuals with disabilities to allow them to do the job. And it also requires us to treat employee medical information confidentially. This law applies to employers that have 15 or more employees. So for many of you that don't have county employees, if you're independent, you may not have 15 employees. However, everything that we say under the ADA applies to employers in the Commonwealth with 4 or more employees. The Pennsylvania Human Relations Act, which is a state employment discrimination law, basically mirrors the federal law. And so, just for the sake of simplicity, I just have up ADA, but that could really say ADA/PHRA. But just know, if you have 4 or more employees, everything that we're going to talk about applies to you. If you have less than 4 employees, well, then you might have a little more flexibility, although I would still recommend not doing the things that would otherwise violate these laws. Under the ADA, before you make an offer of employment to a candidate, you may only ask that one question, that can you perform the essential functions of the job with or without a reasonable accommodation? It's there in the middle of page 7, the language. Phrase it as a yes or no question. Anything else, can't ask about. Can't ask about sick days, what medication you take, are you a drug addict, have you ever been an alcoholic? Any of that stuff you have to stay away from. Common sense may tell you, you know what, I want to know about that stuff. If somebody's a functioning alcoholic, I want to know that right up front. I'm going to ask that. If I've got an employee who called off sick 30 times last year with the prior employer, I want to know that. You're exactly right. All of that's potentially relevant to the job, but we still aren't allowed under the law to get into it. The ways to think about what you can and can't get into in the hiring process, is it relevant? And then if the answer is yes, it is relevant to the job, is it permissible? Because there's relevant and permissible, relevant, impermissible, and irrelevant. And of those 3 categories, we only ever want to get into relevant and permissible. Yes?
The job requires a person to be able to navigate rough terrain. Can you ask them that?
Yes.
That's an actual direct.
There's a good question. The question is, what if the job requires actually being out, in the navigating tough terrain? You're not sitting behind a desk all day. There's physical demands to the job. We had the question on Tuesday, what about if the job requires lifting 50-pound seat bags, things like that? You absolutely can ask those questions. But the way you want to ask that is in the interview, for example, with the seat bag, because that's a good example, can you require somebody to show that I can lift a 50-pound seat bag, carry it 10 feet, put it there? The answer is you can absolutely do that if that's an essential function of the job. Now, my guess is for a lot of districts, you don't have too many employees carrying seat bags around, 30 weeks out of the year. Maybe that's something you only do infrequently. If it's an infrequent thing, we might not want to go there, because one of the types of reasonable accommodations that we may have to offer is the elimination of a marginal function. We don't have to eliminate essential functions. If an essential function of the job is navigating rough terrain, meaning you're out there doing that regularly, it's a big part of the job, it's not something you do once a year or twice a year, yeah, we can make clear to somebody, part of the requirements of this job is that navigating tough terrain, things like that, is that something you believe you can do? We can ask that, because that actually gets to can you do the essential functions of this job with or without a reasonable accommodation? So we can get into that. And if during an interview, if a disability is obvious, or if the candidate raises the disability, don't think that, oh, the lawyer said we got to avoid all these areas, this person's talking about disability, don't put your hands over your ears. Once they make it fair game, you can ask about it if it's related to the job. You can talk about it. Or if you see somebody come into an interview in a wheelchair and you know this job requires trekking up the side of hills and walking along creek beds and things like that, you can talk about that. And so it's kind of you have to be sensitive to it. You don't want to necessarily raise it unless it's really directly related to the job, is the way I would put it. So you can't do really anything pre-offer. The law completely flips. Oh, question?
I had a question on when some of this information comes to you either in the cover letter or in the resume itself. It's not on your application, but they put it out there for you to see. I've seen a lot of resumes that include a lot of this information that you're just supposed to ignore that, or you didn't see it.
The question is, what if it's in the resume or the cover letter? Are you talking about like medical issues or?
More age issues.
Yeah, age issues, you just ignore them. I mean, because if you don't want to know things, but if it's put there right in front of you unsolicited, you can't avoid it. Medical issues, I'd be a little more careful about. If you're looking at a resume or cover letter, and it looks like this person would not have the physical ability to do the essential functions of the job, I would eliminate that candidate from consideration only if it's completely, undoubtedly obvious that they are unable to do the job. One of the things that the ADA really works to fight is assumptions. Well, I assume somebody in a wheelchair can't do this job, or I assume this, or I assume that. And the way to fight that is when you ultimately make a decision, if you have to make a decision on the basis of a medical condition, that it is almost undeniable the person could do the job. And a lot of times you won't get that from a resume or a cover letter. You might get red flags, but if that person is otherwise one of your better candidates, I'd bring him in for an interview. And then maybe explore that, like, look, you've indicated this, that, and the other in the cover letter. This is what this job requires. Do you believe you could do that? And if they say yes, great. And you believe that, yes. If they give you a good answer, yes. If they say no, you're in good shape. Or if they say yes and you still have concerns, well, that gets a little tougher, but still. One of the things the ADA requires of employees is, and even applicants in some cases, what's called the interactive process. How do you get to the end decision? And part of the interactive process is going back and forth with that employee or applicant. An employee comes to you, or you learn that an employee has a medical condition that may affect the ability to do the job. You don't immediately respond, all right, this is what I know, so here's our decision. You go back and forth with that employee. You get information. You can get medical information in that situation. You gather information. You interact with that employee. So then, when you make a decision, it's an informed one. And that's really the goal with any medical issue, with an ADA accommodation type issue. Yes?
Could you explain, excuse me, reasonable accommodation?
Sure. A reasonable accommodation under the ADA, it's the only discrimination law that requires an employer to take affirmative action, not affirmative action as we know, but to do something. All the other discrimination laws are don'ts. Don't do this, don't do that, don't. The ADA is the one that says don't, but also do provide a reasonable accommodation. And what a reasonable accommodation is, there are three types. First is to make some sort of modification to an employee's current job that would allow that employee to perform the essential functions of the job with or without a reasonable accommodation. What could that be? An employee who has very terrible eyesight. If you get a magnifying glass, that will allow the employee to read the reports or read read the plans and that the employee has to read as part of the job. That's a reasonable accommodation. Something that would somehow modify that job. It could be the elimination of a marginal function. Say twice a year you do a seedling sale. I know my home district does that, things like that. And part of that you got to require heavy lifting as part of the job for this job. If they only do it 2 days out of the year, that's not an essential function of that job. So one accommodation would be, we're going to have somebody else carry those seed bags for you because you medically are unable to do so. So looking at the current job, are there ways that we can make modifications to that job, not eliminating essential functions, but what are the essential functions of the job? What are the marginal functions? What is this, an essential function? What is this job really about? What does it really entail? What are the day-to-day key things the employee needs to do? Is there anything we can do to allow the employee to do those, to assist the employee in doing that? That would be one type of reasonable accommodation. Now, now there's a second type, and that is, what if you have an employee who, God forbid, is in a terrible auto accident and comes back and is now in a wheelchair permanently? And that job required navigating tough terrain. Clearly, that's an essential function of the job. Clearly, this employee cannot do that. There's no accommodation that we can offer that will allow the employee to do that job. Well, the analysis doesn't end there. The next question is, do we have any vacant positions for which the employee is qualified that he or she could do with or without a reasonable accommodation? For most districts, the answer is going to be no, because you're small. You don't have 1,000 employees. You don't have lots of open positions. But still think about it. Is there anything, we're not creating a job. That is not required under the law. And sometimes employers can even get in trouble doing that. It happens a lot with workers' comp claims. You want to get somebody back to work, so we're going to create a position, which is fine, a light duty position, but then you create that, it goes on for 6 months, you never put an end date on it. Guess what? That now is that employee's position. So then when you go and say, I want to make you go back to do your real job, you get grief there, but that's probably too much, an issue not worth getting into. But know that, do you have any vacant positions for which the employee is qualified? That's a reasonable accommodation. And the third and final type of reasonable accommodations, which we'll talk about this afternoon, a leave of absence of a finite duration. Say you have an employee who comes to you and says, I need time off because of a medical condition, or I need to intermittently miss work because of a medical condition. If that medical condition rises to the level of disability, which under the law as it currently stands, they almost always do, because the definition of disability has the floor has been lowered to the point now that many medical conditions qualify as disabilities. We'll talk about that later. You may need to give time off as a form of accommodation. It doesn't have to be indefinite time off. It doesn't necessarily have to be 4 days a week indefinitely, but you at least have to look at that possibility and determine whether the time off would be reasonable in light of your circumstances. So like I said, we'll talk more about the ADA later, but that generally speaking are the three types of reasonable accommodations.
I don't want to continue this too much longer, but back to an essential part of the job. I don't know about the rest of the districts, but for my district, some of the essential parts of a specific position would be to acquire funding, plan, and coordinate, say, riparian plantings along the stream.
Okay.
And you have a finite season in which you can do that. You may only do 2 or 3 plantings in that season, or maybe a half a dozen. It varies from year to year. Is that an essential part of the job?
It could be. The question was, if a critical part of the job is doing plantings and seedings along a stream or creek bed, and you can only do it, 2 months out of the year, I don't know how many, but it's not very much in the growing season. Even though you're not doing, the employee's not doing it 12 months a year, can it still be an essential function? And the answer is yes. There's really no bright line test on what is an essential function versus what is a marginal function. So really, that's one area where I would say use good judgment and common sense. And one of the best ways to memorialize that is have written job descriptions. If you have as the employer put thought into, if I look at this ag tech's job, what are the essential functions of this job? What do I need an ag tech to do for me? That's what you list as the essential functions of this job include the following bullet points, and then a nice catch-all at the end that says, and other duties as assigned, by the district or whatever. You don't necessarily need to identify marginal functions, but just if you have that on your list, now again, use good judgment. You can't put every single thing the employee does as an essential function because that's not true. What's an example? I'm an attorney. What are essential functions of my job? Analyzing, interacting with clients, giving presentations like this. I also occasionally make photocopies. If my secretary's not available or I'm a do-it-yourselfer type anyway, I'll just go to the copy machine and run off a bunch of photocopies. I do it occasionally, maybe once a week. making photocopies is not an essential function of my job as an attorney. So think of it through that lens. What is this job really about? What do we employ these individuals to do for the district? Those tend to be your essential functions, even if they're not done every day. Now, if they're done every day, that's great. But if it's like a seasonal thing where during this season, this is a critical aspect of this job, yes. But if it's more on the marginal side, that's where you would want to look at, okay, this is something that we can, because you never have to hire somebody to do the essential functions of the job. If the job entails driving around and going to properties and going to areas, and the person, say now, can no longer drive, you don't have to hire somebody to chauffeur that person around. But if driving was just a marginal function, an occasional thing where twice a year they had to drive somewhere on average, then maybe we do have to restructure things. So then there's no black and white on what's essential versus marginal, but use good judgment. Post offer, the law flips. Now you can ask anything you want after you make a conditional offer of employment to the employee. But beware of what you ask for, because you have to do it post offer, because at that point, if you yank that offer, there's no dispute why you yanked it. You can't say, well, we pulled the offer because someone else is more qualified, or we pulled it because you weren't, your educational experience wasn't good enough. No. We've already made the offer, and it was conditioned only upon a medical inquiry or examination. So now, if we yank that offer, there's no doubt about it. It's because of the medical history, and we can only yank the offer because, for reasons related to medical issues or disabilities, if we can show that the decision was, the factors were job related and based upon business necessity, meaning clearly this person couldn't do that job. Because if it's one of those, this job does have some physical component, we did a medical, we have everybody who applies for this job go get a pre-employment physical, the physical showed maybe a back injury in the past. Did the healthcare professionals say this person cannot do the job, or just raise the back injury? If you not hire now, it can get mushy. So you can ask for a lot of stuff post-offer, and we talk about that on page 8, but it's not necessarily risk-free to do so. What I generally say is, and you've got to ask, if you're going to have somebody complete a pre-employment physical, you must require that all individuals who receive post-offer or who receive conditional offers of employment have to also complete the pre-employment physical for the same position. You can't hire 3 ag techs and send one of them to go get a pre-employment physical because you don't like the looks of the way so-and-so walks or whatever. You've got to be consistent and uniform with respect to at least the position. So I don't know how many districts do post-offer pre-employment physicals. I don't think it's a lot. What I would say is it's something to really seriously consider only if the job has a very physical component to it. Otherwise, I think the risks outweigh the rewards and the cost, because you have to pay for this, of doing a pre-employment physical. References and background checks, that's on page 9 and 10. We've talked about a little bit about criminal history, doing a background check, getting someone's criminal history. A couple points I want to make there. I said that when you hire, you can only consider felony and misdemeanor convictions to the extent that they are related to the position in question. What about a current employee? What if you have a current employee who gets arrested? The law that we're talking about here with has to be a conviction, has to be felony or misdemeanor, only applies to the hiring process. It does not apply to current employees, meaning employers have far greater discretion if you have an employee who's arrested on what to do with that employee. I know one of the districts that I talked to at one of the seminars had a very difficult situation where they had an employee who was arrested and charged with a particularly unpleasant crime. And that crime got some notoriety. That notoriety got into the paper, linked to the district. The next thing you know, they had a public outcry, why are you employing someone who engages in X, Y, and Z? And what to do in that situation. If you find out an employee's arrested, all options, at least theoretically, are on the table. You can fire an employee for that. Now, sometimes that may be overly harsh. It may be unnecessary. It's not a one-size-fits-all remedy to a situation, but it is an option that's on the table. One thing that I've advised clients in the past in situations similar to that, maybe where you don't want to go all the way and fire somebody because of an arrest, because the bottom line is Under the criminal justice system, one is innocent until proven guilty. We're not the criminal justice system, but still, we want to maybe not go right ahead and say, we're going to fire you. How about this? Okay, you've been charged with this crime. This creates a problem for us. It's something that concerns us. We're going to put you on an unpaid leave of absence. We are going to terminate your health insurance benefits effective the end of the month and COBRA you. We'll put you on an unpaid leave of absence. We can't guarantee we're going to hold your position, but when and if this matter is resolved, get back to us and we'll see, let us know the result and we'll see what we can do for you. What is that? How is that different than terminating someone? No pay, no benefits, no promise of future employment. It's what I call a soft termination. It's not as harsh and stark as saying you're fired, but it really doesn't lock us in at that point, because then we can say, look, this person is on leave pending the resolution of these charges. This person's not working, he or she's not an active employee here. Can get some of the notoriety and publicity off your back without coming right out and firing that employee. And the reality is, in many of those situations, you never hear from that employee again, because especially, I would say, with federal crimes, the feds don't bring charges unless they ultimately get a conviction. States are a little different, but it's an option. That soft termination option, the unpaid leave of absence, is an option to consider if you're ever in that difficult situation where you have an employee who's been charged with a crime. Reference checks, just want to touch on that briefly. You get a call from a prospective employer of a former employee wants to talk to you about that former employee. Can you provide me a reference for the former employee? Are you obligated under the law to provide that? Generally, no. Unless, there's certain, I know truck drivers trucking companies, there's the commercial motor vehicle drivers are required sometimes employers to provide information about prior drug tests. School code might cover some, but for you folks, no. You don't have to provide any reference information. The law provides immunity to employers who provide reference information on former employees in response to an inquiry if they provide that information in good faith. When you have a former employee who is a particularly, it did not end well, it's not one that you remember fondly. The number one goal you have with respect to that employee is to never ever deal with that person again. You've got no skin in the game at this point. You want it all to be past tense. What's one way to have it become present tense? You provide negative reference information, that person doesn't get a job, you're lying about me in the community, you're besmirching my good name, I'm suing you for defamation. Now you have a former employee suing you for doing something that you weren't legally obligated to do. Now, yes, there's immunity for providing reference information in good faith. Well, guess what? Then you get sued, and then the issue is whether you had good faith to lie about the employee. You know it's not a lie, but you still got to deal with it. You still got to deal with that out there. So what are your options? Well, I can lie and provide positive reference information. I don't recommend that. I never would recommend anybody providing anything untruthful. It's just not worth it. So then your other options provide only neutral reference information. Look, I can confirm so-and-so's dates of employment, positions held. Can't go wrong there. And that is why a lot of employers have policies that they only provide neutral reference information. You got no skin in the game. It's not in your self-interest to provide more. I'm not saying you should do that or have to do that, but if you ever run up against that stone wall, why won't anybody give me any good reference information on prior employees? That's why. They want to avoid that. Well, what about just providing good information? That's okay. You're not going to get sued for providing good information if it's honest and truthful. I got no problem with that. But, it's still, if you're looking for an easy way out, we as a district have an internal policy that we only provide neutral reference information. That's the easy way out. It's available if you want to take it. You don't have to, but just be aware that if you're going to provide negative information, even if it's to a buddy of yours, you're putting your neck out there and really getting little or to nothing in return other than being a good citizen who's trying to helping somebody make a bad hire in the future. Criminal background checks, in most situations, they're not required under the law. There is, on page 10, we talk about a provision of the Child Protective Services Law that requires employees hired into position with significant likelihood of regular contact with children in the form of care, guidance, supervision, or training to obtain state criminal history checks, the FBI national check, and the Pennsylvania Child Abuse History Record check. This is a relatively new law that is what I would describe as a well-kept secret. There is a separate law under the school code that requires schools to mandate criminal history checks and similar checks for candidates, people who are going to go into schools and interact with children. I don't know to the extent that you folks work with envirothons at your high schools in your district, things like that. You may have come across this where a school said, if you're going to send anyone here, we need a criminal background check. That's fine. I would defer to the schools on that because the onus is on them, not us. Just be aware that if they require it, that's why. Whether this Child Protective Services law applies to us, it's very fact specific with respect to the job in question. If you've got employees who regularly supervise, guide, care, or train children, you might want to think about requiring this because there's very little guidance out there on what this really means. The examples given in the law of to whom this applies, medical professionals, clergy, counselors, people who have a lot of one-on-one interaction with children. I don't know to what extent any employees at your districts would be similar to that. My guess is probably not. You can't go wrong by requiring checks, as we've talked about. I mean, that's the trend. But just be aware that this law is out there and it is not well known, and really, I've never seen it enforced against anyone. And frankly, there's no guidance that I'm aware of really further defining what is a substantial likelihood of regular contact with children mean. That's legal gobbledygook. That those words mean nothing. I mean, I don't know what that means. Is that once a week? Is it once a month? Is it once an hour? So just be aware that that's out there, and you probably will see it more with schools requiring it, because the school code provision actually applies to both employees of the schools and independent contractors. So it's a very broad law, and frankly, one that's only going to get broader. It's a very easy law to pass in Harrisburg, is more background checks on people who, making sure that pedophiles don't interact with our children and things like that. So I think that this is something to keep an eye on because these laws just keep getting broader.
Our district, we do criminal background checks, and you have to have a criminal background check to get the Pennsylvania child abuse history.
Okay.
But me as a manager for the district, and I'm unable to get that Pennsylvania child abuse history. The actual employee has to apply for that.
Correct.
And the results are sent to that personnel. If it's required, why can't I go in and check that, get that child abuse history?
The question was the Pennsylvania Child Abuse History Clearance. That is not something that you as an employer can obtain. The state criminal history, you can get that two ways. You can either go directly through the state police and their website and obtain it that way, or you can contract with like a third-party background check company who will do the legwork for you. But you are correct, the child abuse clearance, that is given to an individual, not to an employer. And that's actually kind of, in my cynical mind, a blessing, because you know what? It's less work for us to do. We tell a candidate, you got to get these checks and bring them to us. That's how it works in the school environment. Teachers know that schools don't run these checks. Teachers have to come with all their checks in order to submit to the schools when they're applying for a job there. And one of them is the child abuse clearance. So there's nothing, what you would basically say to somebody there is, part of this job and condition is we need to get your criminal history and your child abuse clearance. You've got to get that for us and provide that and give instructions on how they do it. I think there's a cost. There might be a cost.
Yeah, it's $10.
$10. It's de minimis, but they have to do the legwork. You just get to sit back and make them bring it to you. I've had questions asked of me. Well, how do I know they haven't forged it or something like that? The reality is just look at it and use your best judgment, because the law requires them to bring it. So we're not going to get sued for not pulling it ourselves because we can't. All we can do is act as a reasonable person and take a look. But that is the way it is, and it can slow down your hiring process. It can be a pain in the neck, but there's really no way around it.
I mean, for legality, what we do is once the employee gets it, they have to bring the original so I can photocopy the original.
They require the original, and that's a good practice to have, and then make a copy of it. And then you have it on file, because then what will happen, if you have any schools you work with who demand that, they'll say, I need this stuff, and you'll be able to produce it right out of the file. Yes?
We have some 4-H volunteers that help us and stuff, and as employees. And one thing we've done is they have to go through all that process to be a Penn State 4-H volunteer anymore. since I made him go through it like 3 or 4 times, we just said, well, when you get that, bring us a copy. And call that good for our purposes, is that?
Yeah, the comment was about 4-H volunteers and requiring them to bring their own criminal history checks and the child abuse clearance. That's fine, and that actually raises a very good point, and the question is volunteers. All of the laws that we talk about apply to employees, and even this one about substantial likelihood of regular contact with children, that's an employment law. It does not apply to volunteers. Now that said, I work with a number of groups that engage volunteers on a relatively large capacity to care for, supervise children. One example that I can speak to, because it's not a quiet one, is the Girl Scouts. You know, if you want to, most Girl Scout organizations require volunteers to submit their own background checks. The same requirements that they apply to employees. You got to bring to us the 2 criminal history checks and the child abuse clearance. The law doesn't require you to have volunteers do that, but frankly, if these volunteers are functioning like employees and have a lot of one-on-one contact with children, not a bad thing, not an unwise thing to do. Let's put it that way. You know, it's something that, you know, because you're just trying to avoid that 1 in a million situation where something happens. So, whether it be for volunteers or employees that you don't think are covered, think about the situation. How often are they interacting with children? Is it supervised? Is it alone? Is it in groups? Is it individual? Do we want to require this? There really is no right or wrong answer. It's your comfort level. Do you sleep better at night knowing you require this? If the answer is yes, then do it. If you say, you know what, I think that's overkill, or I think that making our volunteers jump through these hoops would be too much, then maybe you don't. But there's no right answer necessarily.
One question on the Pennsylvania child abuse history. Do other states share that information with Pennsylvania? Let's say they're convicted in Utah of a crime against children. Does that show up under Pennsylvania?
That's a very good question. The question was, do out-of-state child abuse reports show up on a Pennsylvania child abuse clearance? I don't know the answer to that, so
I thought I heard it was just Pennsylvania.
I know a Pennsylvania criminal history check will only show Pennsylvania convictions. That's why some employers who do extensive criminal history checks, what they will do is contract with a third-party background check company to do a national check when you have an employee perhaps who's lived out of state within the last 5 or 10 years or something like that. The Pennsylvania one, the child abuse one, I don't know, but I can get an answer for you on that.
And that can go on a card? If you put that on a card, we'll address it in the webinar.
Yeah, that'd be great. If you can take one of those index cards and just write down, I'll remember if you can put out-of-state child abuse. That's a good question. Yes?
I've undergone both checks, both from a scout leader standpoint and a school bus driver standpoint. The scouts have a 2D policy for adults, that there's never an adult alone with a child too. So there are things you can do even outside those requirements for volunteers and employees, policy-wise, to never, you know, have a child alone with a single adult. Always have enough adults to go around. You know, if it's like envirothons, I think we have walkers that take kids to the restroom. There's, you know, 2 adults that escort the kids out of the group and back to the group and those kind of things. So there's even some policy things you can do to
that's an excellent point. The criminal background checks are not the end-all be-all. You know, it's still, you have to pair that, if you go that route, with smart policies that, again, make you feel comfortable and protect children. And a perfect example of that is a policy that prohibits employees or volunteers from being one-on-one alone with children. You know, the scouts require that. You know, I see that in a lot of churches too, where, you know, any Sunday school classroom has to have 2 people in it at all times, 2 adults. You know, and that, I think if it's feasible, that's a good practice to have. For our perspective, for conservation districts, you know, it's certainly not a bad idea, but it's also, I'd say, less imperative than for like the Boy Scouts and Girl Scouts, because the reality is, if there are people who are out there that are pedophiles, they will be attracted to organizations like that. I think it's less likely for somebody to say, I want to go work in a conservation district because of these, because of this issue that I have. But still, that doesn't mean I think it is good to review your policies and your practices and make sure you feel comfortable with them. Yes?
Are these background checks, we had an incident where a school did require us to get these before we could go into the school. But as I recall, they were only good for like a year.
Yeah, the question was how long they're good for. And the check, the reports you get don't have an expiration date, but the laws that require it do. And I think the school code is one that does require schools that if you're having someone come in, they need to provide a report that's no more than, it might be 1 year old, or I don't remember offhand, but yeah, if the schools are saying this is too old, you got to get a new one, that's why the law specifically addresses that.
I believe it's 2 years.
Is it 2 years? Yeah, 2 years, something like that, and that would be why. So it really would only come up, it would only come up for those, your employees that work in and with schools. I do not necessarily recommend, just as a practice, running criminal background checks on current employees, absent a pretty compelling reason to do so, because it's just a waste of time. I mean, if one of your employees gets arrested for and convicted of a felony or misdemeanor, odds are you're going to find out about it. So, if Johnny gets convicted of murder, you don't need to run a check to find out about that. So, but in the school context, you absolutely might have to, because that's just the way they operate. Do you have a question, Jen?
No, it was gonna be about the timing.
Okay, great.
Well, actually, kind of along the lines of what you just said, it's obvious that background checks are a hot issue for everybody. We don't require them, but let's say we're hiring for a new position in which we do. You're just saying that you wouldn't go asking current employees for background checks. Is it permissible to do that? Do you kind of make that a requirement for everybody at that point, or is it just kind of draw a line in the sand, date forward, this is a requirement? What are your thoughts on that?
Sure. The question was, what if you don't currently require checks and you'd like to start? Would you then check current employees? My advice would be no. But there's nothing wrong with saying effective April 24th, going forward, everyone we hire for X positions or everyone we hire across the district, we are going to now do criminal history checks. That's fine to treat new employees different than existing employees. And it's fine from a legal perspective, and secondarily, the whole point of a pre-employment criminal background check is to avoid hiring someone where something bad happened. Current employees, you generally know who they are, and even if they do have a criminal history, it'd be very rare that it'd be something that you would then fire a 3-year employee because of something he or she was convicted of 6 years in the past. But yeah, it definitely is. This is a hot and growing trend, and of course, like everything in employment law, it can't just go in one direction. Everything pushes us to do more and more of this stuff, and then the EEOC jumps all over us for doing so. So, the best way to do it is to be smart about it. I talked about what the EEOC asks that we do, and that's on page 11 at the top, is what the EEOC guidance is. Developing a targeted screen that is narrowly tailored, consider multiple criteria, which are listed there, and consider criminal histories on a case-by-case basis. That said, these same laws, the school code and the Child Protective Services law that requires these checks, there are specific laws there's specific convictions under those laws that automatically exclude a candidate from working with children or in schools. So the EEOC is telling us to do one thing and state law is telling us to do something else. We got to follow the state law. Thankfully, the enumerated offenses under state law rarely will come up. You're likely not to get too many employees who are going to work with children who've been convicted of, felony murder or kidnapping or stalking and stuff like that. It's unlikely. Usually, the offenses that you see are not the ones that are automatically excludable, and that's when you want to look at it on a case-by-case basis. Bottom of page 11, we talk a little bit about the Fair Credit Reporting Act, which I mentioned earlier. That applies if you use a third-party consumer reporting agency to do your background checks. If you yourself go to the state police website and pull the reports, this does not apply. If you require employees to obtain their own reports and bring them to you, or applicants, this does not apply. This only applies if you engage a company that does this for business to provide the information. That's when you have to provide the disclosure and authorization before obtaining the report, and then certain notification requirements before you take an adverse action on that basis. Finally, credit checks. Does anyone here do credit checks on employees before hire? My reaction to that is good. The EEOC really does not like credit checks, and it's very hard for me in most situations to justify how a credit check is related to a position. Yeah, if you've got somebody who handles money or runs your finances, perhaps you can justify it then, but it's not self-evident, the link between not managing your finances very well and bouncing some checks and filing for bankruptcy, linking that to essentially theft. and that's really what you would have to show. So it's something that if you don't do it, I'm more than happy that you don't. The law doesn't per se prohibit the use of credit checks in hiring decisions, but it is something that's viewed quite skeptically unless you're talking about like a CFO position or a high-level position, because frankly, how is having bad credit relevant to whether you can do the job or not? I guess you could say poor judgment, but some people have bad credit because of catastrophic medical bills, which isn't a judgment issue. It's a very imprecise tool, and one that the EEOC takes the position that certain minority groups tend to, as a group, have worse credit histories than others, and because this is not related to the job, it's the equivalent of requiring the guy who pushes the brooms for a living to have a high school diploma. It's just not necessary, and it has a disparate impact. Effective workplace policies on page 13. We'll get into this and then break for lunch here in 10 minutes or so. A number of years ago, I did a sort of a model form handbook through PACD. Some of you may remember that or may have seen that. I know I've worked with a number of districts directly with putting together their own employee handbooks or policy manuals. Worked with Jan with Allegheny County just this year and putting together a handbook. I don't want to put you on the spot, Jan, but you offered at the last session. If anyone is interested in a starting point, I would say, on a handbook that I just reviewed a couple of months ago, Jan graciously offered to make that available to the districts at our last session. So what I would say is, if you don't have a handbook or policy manual, you should have one. It's no longer debatable. It's something that there's so many laws that either require policies or strongly encourage employers to have such policies. It's good to have one. One size does not fit all. There are some policies that are legal boilerplate, that everyone should have essentially the same policy. But most policies need to fall into two categories. One, they need to reflect your culture and your practices. I can't emphasize that enough. Nothing drives me crazier than when I have an employer who comes to me and is complaining about all this sick leave they have to give to an employee. And it's one thing to come to me and complain about all these obligations the law puts on you. The law does not mandate paid sick leave for anyone. You, as an employer, define whether and to what extent you offer paid sick leave to employees. Now I say that. Do any of you have any union represented employees at your districts? That is, we are 3 for 3. All 3 seminars, no one has any union represented employees. The reason I say that is you don't have carte blanche if you have union represented employees. You have to negotiate that with the employees' union representatives. But for the rest of you, if you want to offer sick leave or not, if your employees are not county employees, meaning you control the policies, that's your call. So make sure that what you offer is what you want to offer. And importantly, and even more importantly, make sure that your policies reflect 2014 where you are right now. If you have an employee handbook that was prepared in 1998 that you still hand out to employees and keep on the top of your dusty shelf in your office, don't hand it out to your employees anymore. Or before you do so, read it and ask yourself the one question: is this what we do? If the policies reflect your current practices, great. But if the answer is, no, this is what the manager did 4 managers ago, and this isn't in any way what we do when it comes to vacation, or what we do when it comes to an attendance policy, don't distribute it to people, because a handbook needs to be accurate and up to date to reflect your current practices. If it doesn't, revise it. Issue a memo supplementing your handbook saying this is our new vacation policy, or this is our new attendance policy. Don't hand out something that doesn't reflect your culture anymore and frankly violates the law. So you're going to have some policies legally required, legal boilerplate. But for all your other policies, I would say they need to reflect your culture and your current practices, and they need to not violate the law. They may not have legal boilerplate language, but there's a lot of areas that you don't want to get into. Don't say it if you're unwilling or unable to live with it. It's as simple as that. If you don't want to, I had somebody, it's not a perfect example because this was a district that has county employees. She explained at one of the seminars that the county has a very generous sick leave policy and provisions, and the district employees avail themselves of that sick leave, and then the county gives her a hard time. Why are all your employees taking off and using all this sick leave? Because it's offered to them. If you don't want to, then don't. It's as simple as that. And now, sick leave, one thing you can always do is change benefits, change things prospectively. You know, you can change really anything and go back and issue a policy and say, effective April 25th, this is the district's new policy on blank. That's fine. You can't change things retrospectively or change or somehow adversely affect benefits or wages that employees have already accrued. So if you basically have a vacation or sick leave or paid time off policy whereby employees maybe perhaps earn their 2015 vacation or 2014 paid leave in 2013, meaning you work this year to earn next year's paid leave, you can't now say we're changing the paid leave you have in 2014. What you say is we're changing the paid leave you have starting January 1, 2015, where they haven't earned it yet. You got to be careful about that, especially in paid leave situations. If employees currently can accrue unlimited sick leave, you can't necessarily say effective April 25th, all sick leave that accrued more than a year ago is gone. There's ways you can address that and nuance it, but just be careful about that. Don't go in with a red pen and just change things that may affect benefits that employees already have earned. You can change things going forward. You can change how they accrue sick leave going forward. You can now say you have to, if you don't use your sick leave by X date, it will fall away and you will lose it. Those things you can change, but just be careful about how you go about doing that in situations where you're dealing with already accrued benefits and wages. We can't cover everything in a handbook in a session like this or even in a 100-page document. But I want to touch on a couple key policies or policies that are very hot right now for employers, or have always been hot and should be in any employee handbook. As none of you have union represented employees, all of your employees have the presumption of at-will employment, meaning unless one of the exceptions to at-will employment applies, the most common of which is having an agreement that says you're employed for 3 years and can only be terminated for just cause or something like that. Absent that, every one of your employees is an at-will employee. Under Pennsylvania law, that means that either the employee may quit or you may fire the employee. Either side can terminate the relationship at any time, for any reason, with or without notice, as long as that reason is not otherwise inconsistent with the law. And at-will employment is very important for purposes of a handbook. You don't want a handbook that somehow creates a right for an employee to continue his or her employment. You don't want anything in your handbook that would imply or infer that you're anything other than at-will. Where is at-will employment not important? I commonly get the call or the statement from employers, well, why do I have to worry about all this junk? Why do I have to document stuff? And why do I have to do all this stuff that I'll talk about this afternoon with discipline and discharge? Pennsylvania's an at-will employment state. I can fire them at will. Correct. As long as that reason is not otherwise inconsistent with the law. And the way to think about it is at-will employment is the rule. It's a circle. And if you turn to pages 56 and 57 of the written materials, these are all the ways listed there, 1 through 10, the various different ways that terminating someone's employment is inconsistent with the law. If you fire them for filing a workers' comp claim, for filing an unemployment comp claim, for jury duty, for raising a complaint under the wage payment collection law, for discrimination, all of those are exceptions to at-will employment. I can fire you because you happen to be a Browns fan instead of a Steelers fan. That's not protected. I can fire you for that reason. Silly, stupid reason, but that's at-will employment. Doesn't matter if the reason's good, bad, or indifferent. I can fire you because of that. But the problem is, under all of these laws, these are all exceptions that have taken bites out of that at-will rule, so that now the exceptions have made the rule about that big. And what happens is, every one of us has lots of protected traits. Every one of us can file a discrimination claim on the basis of many different reasons. Discrimination is not discrimination because of minority status. It's because of a protected trait. I am white. I am a male. My national origin is the United States. My religion is Protestant. I don't have a disability. I am not protected under the age discrimination laws, as they only kick in at age 40, so I've got a little bit of time left before that applies. But otherwise, I've got lots of protected traits. I'm married. I have a high school, well, say I had a GED. That's protected under Pennsylvania law. So you fire me, I can come back and say you discriminated against me because I'm any of those things, one or all of those things. You fired me because I'm a man. You fired me because I have a national origin in the United States. You might have heard the phrase reverse discrimination. There's no such thing under the law. It's just discrimination. And anybody can bring a claim on the basis of any reason. And as when we talk about this afternoon, about how you bring a legal discrimination claim, it's not very hard. So the reality is, while everyone's at will, you can't think that's not a defense to a discrimination claim or any of this. It's a sign of a lack of sophistication, quite frankly, with respect to these laws. Meaning, if I stood up in front of a judge and said, "Judge, they allege we fired the plaintiff because of her religion. Instead, we respond that she was an at-will employee and we could fire her for any reason we wanted," I would get laughed out of the courtroom. It doesn't matter. The exceptions have swallowed the rules, which is why when we talk this afternoon about all this stuff, if you're sitting there thinking at-will employment, we're good to go, no. We're on trial, our reason's on trial, and we can't rely on at-will employment in the face of a discrimination claim. Where we rely on it is in the face of a claim that I wasn't at-will. You said you would employ me for life. Or, oh, you're 62? That'd be great, we'll hire you, and then you can work until you're 66, and then you can retire or whatever. That's what you want to avoid, because that seems to be a promise of something other than at-will employment, a 4-year employment contract. That's where at-will matters, but not on the reasons why we fire people. All right, equal employment opportunity policy on page 16, that is legal boilerplate. That does list all of, or most of the protected traits under federal and state law, including, as I mentioned, possession of a GED in lieu of a high school diploma. Can't discriminate under state law on that basis, including genetic information. So how many of us discriminate on the basis of genetic information? And no, I don't mean ugly people versus non-ugly people, because that's all genetics too. No, what that means is genetic information. We essentially are, that's a recent law that was passed. What does that really touch on that matters? Family medical history. Some employers for a long time, their pre-employment medical questionnaire, as suggested by medical professionals, have you or any family members ever had the following conditions or diseases? Can't ask about family medical history because that gets to genetics. Not anything that we would probably ever come across, but that's why that's silly.